Good morning and welcome to the new edition of Dr. Lamba's Awakening. Indian political system is a strange animal. Independence came, country was divided, and one part of the country very clearly said they are going to be Islamic. Good enough. There's nothing objectionable about that. Every country has a right to have a system best suited to it. And Indian leaders, in a frenzy of modernity, large heartedness, unmindful of the millions of the people killed, said no, they would be secular. Again, great. Great from the point of view of humanity, great from the point of view of Indian tradition and Indian culture. But then the contradiction started creeping in. Can you believe that in India there are almost 100 religions? I'm not talking only of Christianity, Islam, Hinduism, Sikhism, Jainism, Buddhism. But if we look at the tribal areas, if we look at the northeastern areas, practically every village has its own way. And even if I look at the religions in the accepted sense, there almost every religion is there in India. And that shows that the people of India are always willing to have a system best suited to it, something which is great. But look at it. They look at the reality. No other religion has its personal law board except Indian Muslims. The institution of All India Muslim Law Board is peculiar. Eh? It exists in no other country in the world which is multicultural and multi-religious, where the diversity and plurality of life is accepted. But in India, it is there. Christianity, a much smaller minority community, doesn't have Christian law board. Sikhs don't have a Sikh law board. Buddhists don't have a Buddhist law board. Jains don't have a Jain law board. But Muslims have an all India Muslim law board. And they say it is a non-governmental organization. It was constituted in 1973. And the purpose was to adopt suitable strategies for the protection and continued applicability of Muslim personal law in India. More importantly, the Muslim personal law, which is Sharia, Application Act of 1937, was sought to be invoked. So that goes inherently against the Constitution of India. And no organization can be set up which is anti-constitutional, which is unconstitutional. Anti it is, but it's unconstitutional automatically. And the beauty is that this law board is funded by the government of India. Government of India funds an organization which promotes division, which promotes Sharia, which is at variance with the Constitution of India. And the purpose of the law board is that the Constitution should be subservient to Sharia, which is not possible. And the courts have decided many times that this is not acceptable. Now, every act enacted with the government is applicable to the whole country except that Hindu Marriage Act and Hindu Court Bill, which were applicable only to the Hindus. And those religions which just deemed to be part of Hinduism are which came out of Hinduism, like Sikhs, Buddhists, Jains, etc. But even they are being taken up. But apart from that, civil code is applicable to all. Unfortunately, there is no uniform civil code. We had discussed it last time, except in Goa. So this section, the Sharia Application Act of 1937, should have been declared unconstitutional, ultra virus, but this section had the right under laws. There is the Kuchi Memon Act of 1920, the Mohammedan Inheritance Act of 1897, and they say that even the Muslims have a right not to be governed by Sharia. They can opt out of the Mohammedan law. Fazlur Rahman, who was an important part of the All India Muslim Personal Law Board, claimed that the majority of the Muslims follow the Muslim law and not in the Hindu civil code. Fair enough. Because the constitution says that people can follow their religious laws provided they are not in conflict with the Constitution of India and the Indian law. Now imagine Sharia says that the hands of thieves should be chopped off. And according to Muslim law, the Sharia Application Act should be implemented. This goes against the Indian Penal Code and the Criminal Procedure Code. Similarly, a woman who commits adultery should be stoned to death. In this age, where sex celebration is one of the prime qua nons of the population, having such a law would not be possible. And this board, funded by the government, wants that to be done. The board itself presents itself as the leading body of the Muslim opinion in India, a role for which it has been criticized, as well as supported, of course. And it was set up for political reasons. Let's be very frank. It was set up to create vote banks, the way in Canada and other countries do. India, political leaders also did the same thing. Now, most of the Muslim sects are presented on the board, and its members include prominent Muslims, scholars, politicians. However, real scholars like Tahir Muhammad, politicians like Arif Muhammad Khan, retired Supreme Court Justice Markande Katsu, they have all wanted the abolishment of this law, and justifiably. And beauty is that while Pakistan says that Ahmadiyas are not Muslims, but Indians say that no, they are Muslims. However, this law board, personal law board, which gives a sense that it is some official body, which it is not. Ahmadiyas are not supposed to be members of the board. And the board doesn't apply to Ahmadiyya Muslims in India. This biggest contradiction itself takes away that it is basically a Talibanic board. Ahmadiyas are not allowed to sit on the Muslim law board, which claims to represent the majority of the Muslims in the country. Now, it's a private body, they say, but then if it's a private body trying to protect Muslim personal laws, have liaison and influence the government of India. Note the word influence. And this is in the mission statement to influence the government of India. But board is a working committee of 51 ulamas. Now imagine, it is the general body of 201 ulamas. And many of the Muslims, apart from Ahmadiyas, Shias have their personal law board separate. There's All India Shia personal law board. And the women, Muslim women, those who are not downtrodden, who are forward-looking, like have formed All India Muslim Women's Personal Law Board. But the government is not supporting them. That's a no, imagine it. Government is supporting this Sunni, predominantly Sunni Muslim law board. Now, as I said earlier, it focuses primarily to defend the Sharia laws and also oppose the legislation they consider infringes on the Sharia law. So it has objected to any change in the divorce law for the Muslims. It even published a book, Nikah or Talaq, Marriage and Divorce. And time to time it has hinted that it will not accept gay rights and supports upholding the 1961 Indian law that bans marriage or relationship between the people of the same sex. As far as the backwardness of the board is concerned, look at it. It objected to the right of the children for free and compulsory education Act in 2009. Why? They wanted madrasas to be promoted. Nothing against madrasa as far as it's a religious teaching concern. But are they really teaching religion only? Or are they teaching much more than that? And if they're teaching much more than that, why should madrasas not be covered by the groups? Groups of those Muslims who are educated, MGRs, who are more broad-minded, and like that. The board's work, if I look at it, it opposed the Child Marriage Restraint Act. They said, no, an 11-year-old girl can be married. If Aisha could be married at the age of 6 and have sex at the age of 9, why should any girl 9, 10, 11 years old not marry? And the cases have been there. Just the other day, I was looking at a picture. A 33-year-old man marries an 11-year-old girl. There were cases in India where the people from Arid were coming, old people, marrying young girls, 12, 13, 14, taking them. And in one case, an air hostess of Air India at that time had intervened and saved that girl. But they are objecting to the Child Marriage Restraint Act. They also objected to the High Court of India judgment on Babri Masjid, Supreme Court judgment. They said no. And is also willing to threaten political action. It was in headlines for opposing the live video conference by Salman Rushdie at Jaipur Literature Festival, if you remember that. So everything which is reactionary, which is in favor of 14th century Arabic plays, they would promote. And there is a sinister design to impose Islamic belief on, of course, on Islamists, but basically on by influence on anybody. And it's unbelievable. They say they are promoters and the protagonists of Quran, but anybody who has read Quran, how can any sensible person counterbalance and accept the possibility of instant triple talaq? And what does board say? It says, I read, it's a better in comparison to murder, expensive and time-consuming separation proceedings in court. So court proceedings are like committing a murder. And can you believe a body which claims to be made up of Islamic scholars and ulmas, they have shown an appalling ignorance of Quranic procedure of divorce, because they, according to the Quran, the triple talaq is invalid. Triple talaq has to be spread over 3 months. One talaq first month, second clerk, second month, third clerk, third month. And even after that, in a period of 6 months, the parties can come back. So the allocation of enough times to the spouses to resolve is there. So this plea that it saves time is absolutely ridiculous. And whom does it quote? It doesn't quote people who are scholars, but unknown people like Al-Dullah Tuqani, Al-Beghani, and Abu Shaya. The board also highlights the uncivil patriarchy by arguing that in the Sharia, the husband alone has a right to divorce, which is again wrong because Quran is very clear that while men have been given the additional responsibility of being physically and financially responsible, women enjoy legal parity with men as far as fairness is concerned. So, on the whole, whether it was the Shah Bano case, when Rajiv Gandhi stupidly succumbed to the pressure, or in the case of Daniel Latifi, the constitutionality of women was questioned in Daniel Latifi's case. But the Supreme Court put its foot down and it said, no, it's not possible to accept the contentions. The courts have taken a view till now that when there is a conflict between the terms of a uniform code and the rights and obligations of individual groups, then the uniform code would prevail. Law of the land should be applied uniformly. One set of law for Muslims, another set for non-Muslims, would dilute concept of equality before law. The Shah Bano case was, as I said earlier, the horrible thing to do. Then the case of Noor Shaba Khatun, if you remember. In this case, Noor Shaba, the applicant filed for maintenance for her children aged 6, 3, and 2.5. And the High Court said that the maintenance must be given. But Muslim Law Board said no, it should not be given because the children of the divorced Muslim parents living with their mother cannot get it. This was opposed to Section 125 CRPC because the children are entitled to maintenance till they are in majority, or in the case of females, till they are married. Recently, Delhi High Court had to intervene. It rejected a bail application of a man who raped a 17-year-old girl who was a lover. And Muslim Law Board said no, 17-year-old girl, if she has been raped, the rapist is not guilty. But the government, the High Court didn't accept this contention. So we have seen that the Muslim Law Board is basically an obscurantist organization whose basic purpose is to defend the Sharia against any interference with the state and the civil society. And the social reforms are anathema to it. It claims to be a representative body of the Indian Muslims. And as we have seen, all the ulamas on this, I was quite amazed because in Islam also there's a lot of division. But Muslim Law Board has all the ulama of Hanafi school, Shafi, Maliki, Hanbali, Jafri. These three schools have practically no representation of the Muslim Law Board, and they are equally important as the Hanafi school is. The board also doesn't have eminent jurists, social scientists, or political personalities. So questions have been raised according to how the money is being spent. Government gives the money, but there is no audit. The result is that the board is losing its relevance. It never had a relevance as a matter of fact. And the aim of the Constitution of India to establish secularism, hence personal law boards, are unconstitutional and ultra-virus. It was established with an ulterior purpose, which is to divide the society. It has lost, if it had some relevance at that time, it has lost its relevance altogether. And it's high time that the government of India just abolishes it, declares this as a law or as a board which has no relevance at all. If it does so, it's quite possible that it'll be easier to have uniform civil code, which is a prime need. But the first step should be abolish this board. And if you don't want to abolish it, okay, then withdraw funding. Let the government not fund those institutions which are unconstitutional and they are acting against the interest of the unity and the peace in the country. I dare Modi government do it today. Thank you.